mundo, bienvenido a mi canal. Yo me llamo Sirey. Soy una abogada latina licenciada practicando las leyes criminales, pero como todos ustedes, a mí me fascina cuando estamos hablando de casos de crímenes reales. En este video vamos a hablar del caso. Bueno. Espérate. Vamos a seguir hablando del caso de Donna Adelson. Si quieres más video en español, nada más dime allá abajo. Hi everyone and welcome back to my channel. My name is Desiree. I'm a licensed and practicing Afro-Latina criminal attorney who, much like the rest of you, has a severe fascination with true crime cases. You guys, I think our obsession with this Donna Sue Adelson trial, or the Adelson trial et al., is not over. I relatively recently had the idea that even though this happened a few months ago now, I'm lying, 1 month ago now, that the court denied Donna's appeal, I figured we should talk about it. So without further ado, let's go ahead and get into the continued saga of Donna Sue Adelson. If you're new here, welcome. And if you're returning, thank you so much for the continued support. I'm not going to get into everything that happened in the whole saga of Donna, Charlie, Wendy, Dan Markel. I'm not getting into any of that because there are so many videos on this channel where you can refresh yourself if you feel like you need to. But for everyone who's already caught up, let's just get into it. As you guys already know, Donna Sue Adelson was convicted of a few charges relating to the murder of her former son-in-law, Dan Markel. Within 2 weeks after the conviction, Donna's defense team filed an appeal requesting a new trial. Well, I figured today would be the perfect opportunity for us to get into exactly what that motion says. This was e-filed into the court system on September 15th, 2025 at approximately 9:08 p.m. The motion states, defendant's motion for new trial and for leave to interview jurors. It continues, defendant Donna S. Adelson, by and through the undersigned counsel, pursuant to Florida Rules of Criminal Procedure, respectfully requests that this court grant a new trial, and in support thereof, states as follows. 1. A jury convicted Ms. Adelson as charged in the indictment on September 4th of 2025. 2. This motion is timely filed within 10 days of the rendition of the verdict, pursuant to Rules 3.575 and 3.590A. 3. Mrs. Adelson requests leave to interview juror number 5 and juror number 7. And 4. Mrs. Adelson files this motion for new trial on the following grounds. 1. Juror misconduct. 2. Verdict is contrary to the law or weight of the evidence. 3. The court erred in a decision of any matter of law which arose during the trial. And 4. For other cause not due to Ms. Adelson's fault, she did not receive a fair and impartial trial. Before we get into the specifics of their arguments, let's just talk about the bullet points as articulated here and my thoughts on this motion as a whole. I tell you guys in numerous situations that a lot of times things are just filed as a matter of procedure, and I feel like that's exactly what happened here. As articulated in the motion already, before we even read any further, they state that they only have 2 weeks under Florida law to raise and file their motion for appeal or a new trial. They did that. And they're doing it, I guess, to preserve the record would be my best way to say that. I am not offended that they filed this. You should not be offended that they filed this. And I mean, I don't even know if the court would be offended that they filed this. It is very rare, extraordinarily rare, for a conviction to happen and for defense not to challenge that conviction or those convictions. So I just want you guys to keep that in mind as we review exactly what it is they're saying. Motion for leave to interview jurors. In the court's preliminary instructions to the jury, the standard instruction was read. The standard instruction reads as follows. You are also not permitted to communicate about this case with anyone, including your spouse, family members, friends, neighbors, and even your fellow jurors. No communication includes no in-person, telephonic, or electronic communication, such as emailing, text messaging, posting information on social media or a website, or any other form of communication. Subsequent to the trial, juror number 7 went viral on TikTok concerning her jury service. She revealed that she posted to TikTok during the trial. In reviewing juror number 7's TikTok account, the undersigned identified she posted on TikTok that she was selected as a juror on August 26th, 2025. A flash drive with this video will be provided to the court as the undersigned has been informed that particular TikTok was deleted by the juror from her account. Additionally, juror number 5 appeared on the podcast Surviving the Survivor. During his appearance, he revealed he considered how Ms. Adelson reacted to the evidence and testimony during trial. Although he subsequently stated he obviously did not consider that during deliberations, that he considered Ms. Adelson's reaction whatsoever is concerning, as her reactions are not evidence and are extrinsic or external, rather than which inheres in the verdict. So let's just stop right here so I can give you my whole opinion on this argument about juror misconduct. So first, they say that juror number 5 previously posted that she was selected to be a juror in the Adelson case. Do I find that problematic on the date that she posted it because that was during the trial? I do. If defense has nothing further than that she posted, I'm not sure what a new trial would do. Was that juror misconduct? I mean, we can stretch it and give it that definition if we would like. Did the juror violate the court's order if what defense is saying in the motion is true? Yes, it did. Had defense become apprised of this information during the trial and brought it to the court's attention, one of two things would have happened. One, the court would have admonished the jurors yet again, or more specifically that juror. You cannot post on social media, ma'am and or sir. You cannot do that. Or two, replace that juror with a complete alternate. I think that the information provided here is not sufficient enough to say that this juror was well informed about this case or knew about this case prior to presiding on the case. I don't think that her posting or him posting, my apologies, that they were selected to be a juror in this case necessarily means that they had any sort of bias against Donna. And I don't know, that's not the best argument, but I do slightly agree in the sense that the post shouldn't have happened at all. As far as the argument to juror number 7 is concerned, I think it's complete hogwash. It's phooey. It's no sé cómo decir más palabras, no sé cómo decir más palabras. It is just crap, okay? And the reason I'm saying that is this. If you notice, defense team in their argument against juror number 5 were very specific to point out the fact that juror number 5 was posting on social media during the trial. They didn't give us a date about when juror number 7 went on this Surviving the Survivor podcast. So if this juror is talking about the experience after the trial has concluded, so what? And then the argument that this juror was saying that Miss Adelson's expressions were concerning, I mean, what have you? We all have preconceived notions. If I look at someone crying, I assume they're sad. If I look at someone yelling, I assume they're angry, right? You cannot have these people walk into a courtroom and just leave their common sense behind. So that argument made absolutely no sense in the slightest to me. But let's carry on and see what else they argue, shall we? Argument 2 states, verdict is contrary to the law or the weight of the evidence. So I'm not going to give argument too much weight because I think we all can agree that that's just hogwash. The evidence was there. And I saw quite a few comments saying, well, Desiree, you're saying that there wasn't evidence. And that's not what I said. I watched it back numerous times to see where you guys misinterpreted my words. But what I said was that the evidence in that case was circumstantial evidence, which is still a form of evidence. But what I'm saying is the evidence against Donna, in my mind, and in the mind of the prosecutor assigned to this case, wasn't as strong as some of the other evidence that they have against some of the other players. Georgia said it in her closing argument. I even inserted the clip for you guys to see. So arguing with me in the comment section is silly. I'm not going to respond to nonsense. If you have an argument that's based on ration, logic, and not just your feelings and insults, I'm happy to address it. But this is not a safe space. You're not going to talk to me however you want to talk to me. And I just want to make that very clear. Well, let's carry on, shall we? The court erred in a decision of any matter of law which arose during the trial. The court erred in denying Ms. Adelson's request to admit into evidence the complete 2014 planner and 2023 planner. During trial, the defense sought to admit the complete planners to correct the misrepresentations expected to be made by the state and which came to fruition during the state's closing argument. With the 2013 planner, the state argued the planner indicated, in anticipation of fleeing the country, that Ms. Adelson was selling personal items. Admission of the complete planner would have corrected the misrepresentation made by the state, as there were 39 other entries in the planner where Ms. Adelson listed to sell identical items as far back as January of 2023. In Curtis v. State, the court recognized that judges have a duty to admit evidence that does not fit neatly within the confines of the evidence code in order to protect the defendant's right to a fair trial. As the court admitted portions of both planners, there is no question concerning the authenticity of the materials. Exclusion of the planners infringed on Ms. Adelson's right to present a defense, and the evidence was important to defeat the argument that she was fleeing to avoid prosecution. Thus, the court erred in excluding the planners as evidence. Okay, so before we get into the next argument, let me tell you my opinions on this one. The court did not err by excluding the entirety of the planner because it wouldn't have been relevant. And I'm sure, don't quote me on this because y'all like to play internet detective, but I'm sure if I went back and reviewed why the court denied admission of that, it would have been for that reason. We're not going back to 2023 when it's not relevant to the trial here. Your counter argument to me might be, well, Desiree, didn't the murder here occur in 2014? And it did. But what the prosecution was trying to show was that she was selling off some of her items in order to flee the country. So going back to 2023 isn't really helpful to establish or disestablish, in my mind, that she was trying to flee the country. Does that make sense? So because of that, the court did not err, and this argument is bogus. Well, let's carry on and see what else they say, shall we? Argument 4 says, for other cause not due to Miss Adelson's fault, she did not receive a fair and impartial trial. Point 63. This is a case where the cumulative effects of a number of factors constitute inherent prejudice, resulting in Miss Adelson not receiving a fair trial. When the court would rule against the defendant, on many occasions, the members of the gallery supporting the state would laugh out loud. Counsel for the defendant brought this to the court's attention, and the court appropriately advised the gallery that this was not acceptable. The court did this on more than one occasion. However, the conduct continued throughout the trial, and the court took no action to remove those who violated his order. This undermined the credibility of the defense in the eyes of the jurors. The court admonished the defendant on numerous occasions that she was not permitted to show any emotion in the presence of the jury. The law does not require that the defendant appear without any emotion. In fact, as in this case, appearing to be cold to the seriousness and evidence in this case may cause the jury to believe the defendant had no care or concern for what the victim endured. During the course of the trial, prior to reading the verdict, the defendant did not do anything to disrupt the proceedings. She did become tearful during her first sight of autopsy photos and got choked up when her children appeared to testify against her. She did not speak out. She was not sobbing out loud. She was not crying out. She did not need tissues to wipe away her tears, but she made no noises that distracted the jury in any way. Even the victim's parents noted that she showed no remorse due to her lack of emotion during trial. This impacted the decision of the jury, resulting in Mrs. Adelson not receiving a fair trial. Defense carries on to make other additional arguments, but we're not going to read them because I don't find them to be too crucial to my determination that this final argument is also silly. I think this. So, sure, I agree with defense that there's no law that requires a defendant or anyone participating in a trial to appear emotionless. Fair enough, right? But the court runs its courtroom the way the court sees fit. There's no prohibition against any judge from running his or her courtroom in the exact manner that they choose to run it. Some judges like law and order, some judges like recklessness, some judges will allow for more emotion, while some judges won't stand for emotion. It kind of is what it is. And on top of that, I felt like the judge in this case was really stern, but with all parties, not just the defendant, with all parties. And if you're telling me that the jurors walked into that courtroom day after day after day to proceed in this trial and not know that this man was not playing any games with anybody in there, that's insane. This argument is fallacious, and it's without any merit, in my opinion. Shortly after the filing of that motion, the court denied Donna's request for a new trial. And I'm sure we all agree that that was the proper decision. This case is the case that keeps on giving, or at least I hope so. As I said in the last video, or one of the last videos, I'm hoping that we see Wendy charged here soon. What happened to Dan Markell was absolutely ridiculous. It was saddening. It was terrible. And hopefully complete justice for Dan includes the charging and conviction of Wendy. But that's it for this video. Go ahead and let me know what you think down below. Let me know if you guys like these document review videos. The last one I did didn't really do too well, so I'm assuming you don't. But if you do, let me know whatever it is you want to let me know down below. As always, thank you guys so much for watching. Please be sure to like, comment, share, and subscribe. Until next time, y'all take care.